Welcome. Today we are embarking on an extensive examination of a case that um, really consumed Australian public life for years.
We're talking about the saga of Schapelle, the Australian woman convicted of drug smuggling in Bali.
And this is so much more than just a legal case.
It is. It's a profound study in, the clash of different judicial systems, the incredible power of the media, and just how difficult it is to find the truth when you're dealing with international borders and sovereign laws.
The sources we're looking at today give us this incredibly complex, detailed map of facts, accusations, and, of course, denials. It's a story that held the attention of two entire nations for more than a decade.
It really did.
So our focus today is to really break down the factual content. We need to look at her arrest back in 2004, the very controversial trial that followed, her imprisonment, and, well, the enormous public and diplomatic pressure that came with it.
We have to get past the headlines.
Exactly. We need to understand the mechanics, both legal and political, that shape this whole thing.
And we have to ground ourselves in the central incident. So, Schapelle was convicted on May 27th, 2005.
Right.
For the importation of 4.2 kilograms of cannabis. That's roughly 9.3 pounds.
Found in her luggage at Bali's Ngurah International Airport, that one discovery led to a sentence that completely redefined her life.
And from the very beginning, her defense was completely consistent, unwavering.
She has always maintained the drugs were planted in her unlocked bodyboard bag, and that she had absolutely no knowledge of them.
And that question, was she guilty, or was she this unwitting victim of a trafficking operation? That's what kept the public completely hooked for so long.
So our objective is clear. We're going to systematically analyze the key conflicts in the evidence, and there are many of them.
We also need to understand the legal and diplomatic context, which was quite restrictive, and then trace the immense human element of a story that truly became a cultural flashpoint.
Okay, so let's unpack this. We should probably start with her background and the events of that day. To really get the scale of what happened, we need a little bit of context about who she was before all this.
We do. Schapelle Corby was born in 1977 in Tugun, Queensland. Her early life was, by all accounts, pretty ordinary.
She left school after year 11, right?
She did. She partially completed a beauty therapy course, but then went to work, mainly in her family's fish and chip shop and also at a Coles supermarket.
So a very modest working-class background.
Exactly, which makes the sudden transformation into this figure in an international drug case all the more dramatic.
And it's also really important to establish her connection to Bali. This wasn't her first trip.
No, not at all. It was extensive. She'd been there 5 times since she was 16, so this wasn't some kind of, sudden impulse vacation.
She knew the place.
She knew it well, and that was largely because her older sister, Mercedes, was married to a Balinese man and actually lived there.
So there was a legitimate, established reason for her to be traveling there.
A very clear one.
Which brings us to the crucial date, October 8th, 2004, the day everything changed.
That's the day. Schapelle, her half-brother, James Cassina, and 2 friends started their journey. They flew from Brisbane, had a transit in Sydney, and then boarded the flight to Denpasar in Bali.
And that stop in Sydney, that transit, becomes absolutely central to her entire defense theory.
It's the geographic locus, yes.
Yeah.
But let's focus on the arrival in Bali first.
Yeah.
So she gets to customs. Her bodyboard bag is identified and pulled aside for examination.
And inside, officers find it. The 4.2 kilograms of cannabis packaged in a double plastic vacuum-sealed bag.
And this specific interaction right there at the customs bench, it becomes the absolute hinge of the entire prosecution's case.
Because of what the customs officer claimed.
Exactly. Customs officer Gusti Nyoman Winata testified that Schapelle tried to physically prevent him from opening that compartment of the bodyboard bag.
A single claim that suggests she knew what was inside, it implies she was trying to hide it.
Precisely. But her testimony, her version of events, was completely different.
She denied it completely.
She did. She said she never tried to stop him. She claimed that after the officer pointed to the bag and asked her to open it, she was the one who unzipped it.
And she also mentioned the language barrier, which seems plausible.
She said she had difficulty understanding him, which, clouds the certainty of that whole interaction. If she willingly opened the bag herself, that severely undermines the idea that she was trying to conceal something.
So it's an issue of intent versus compliance. But what was truly concerning for the defense and for a lot of observers was the immediate lack of proof.
You mean the CCTV footage?
Yes. The sources confirm a detail that is, frankly, staggering for a high-stakes case like this. No CCTV footage of that crucial customs interaction was ever retrieved or preserved.
That absence is just monumental. In any modern legal system, you would expect objective visual evidence of the moment a seizure like this happens.
And the defense asked for it, didn't they?
They specifically requested it. But according to Schapelle's mother, the judge's response was something like, "We will use that if we need to."
And they never needed to.
It never materialized. This left the entire foundation of the prosecution's case resting purely on the verbal accounts of those 4 customs officers.
How does a lack of objective evidence like that affect a trial, especially under Indonesian law?
Well, it creates a foundational vulnerability that's almost impossible to overcome. And what's more, the defense tried to introduce other objective evidence, and that was also denied.
What was that?
The sources note that the bags weren't individually weighed when they checked in at Brisbane or when they arrived in Bali. Schapelle requested her other luggage be weighed after the drugs were found.
Why? What was she hoping to show?
She was hoping to show an unexpected addition of 4.2 kilograms to the total checked weight.
Which would strongly support the idea that something was added between Brisbane and Bali.
It would have been powerful circumstantial evidence, yes. But the Bali police denied the request.
So every missing piece of standard procedure, the CCTV, the baggage weights, the conflicting testimony over who even opened the bag, it all just compounded the narrative that the initial investigation was, at best, flawed.
Or rushed. It left the core question of her intent completely up in the air.
So moving into the courtroom itself, the legal conflict becomes immediately obvious.
It does. The prosecution's case was remarkably narrow. It relied almost entirely on the testimony of the 4 customs officials and the simple fact that the drugs were found in a bag that she said was hers.
And they claim she said something incriminating.
Yes, they alleged she had said, "I have some," when they questioned her. For them, this was enough to establish a prima facie case.
We should probably pause on prima facie. What does that mean in this context?
Well, prima facie essentially means at first sight, or on the face of it. The Indonesian judicial system, especially for a serious crime like drug importation, it operates under a different philosophy than what many of us in the West are used to. The prosecution just had to establish possession. The drugs were in her bag, and that immediately shifted the burden.
So once possession was established, the court basically assumed a level of responsibility on her part.
Precisely. The burden shifted almost entirely to the defense to prove a negative, to prove that she didn't know, that she had no intent. It wasn't on the prosecution to definitively prove that she packed the drugs herself.
That's a critical distinction. The discovery of the drugs in her control was treated as almost irrefutable proof of the crime itself.
It was. And against that very firm stance on possession, the defense had to rely on a complex and ultimately unproven theory.
The plant.
The plant. The central argument was that Schapelle was an unwitting victim of an interstate drug shipment.
One that was only supposed to travel between Brisbane and Sydney.
Yes, and that it was mistakenly left in her bag and carried on to Bali. This, of course, threw immediate suspicion on alleged corrupt baggage handlers in Australian airports.
And that theory got a lot of traction here in Australia.
It did, especially after Ray Cooper, a former head of operations for the AFP's Internal Investigation Unit, actually testified in her defense.
What did you say?
He said it was a plausible scenario. He claimed it was known within the AFP that passengers were sometimes unwittingly used to move drugs between domestic airports in Australia.
That sounds like a powerful piece of testimony for the defense, even if they couldn't name names.
It was. However, this entire defense strategy suffered a devastating blow years later, and it was self-inflicted.
Right, this came from her own former lawyer.
It did. In 2008, Robin Tampo, who had been on her legal team and was later struck off for professional misconduct, it should be noted, he made a shocking admission in a documentary.
He said he made it all up.
He claimed he had fabricated that specific interstate drug shipment and baggage handler theory.
Fabricated it. As in, he just invented a narrative he knew wasn't based on any direct evidence?
That's what he claimed. He publicly apologized to the baggage handlers. And then to make it even more controversial, he alleged that the former Australian Foreign Minister, Alexander Downer, had told him that he suspected Schapelle's brothers were behind it.
Wow. Tampo's retraction must have completely damaged the public perception of her whole defense.
It did. It turned what seemed like a plausible theory into what looked like a desperate lie. It completely undermined their core argument.
And then there was the other controversial defense witness, John Patrick Ford.
Yes. He was a prisoner awaiting trial in Australia, and he was flown to Indonesia at great expense to testify.
And he claimed he overheard a conversation in prison.
He did. He alleged he overheard that the drugs belonged to a man named Ron Vagenser and that they were supposed to have been taken out of the bag in Sydney.
But his testimony was shaky from the start.
Very tenuous. The prosecution effectively argued it was entirely hearsay and unreliable. Ford was facing his own serious criminal charges, and he refused to name the person who allegedly planted the drugs, claiming he feared for his life.
And his own legal troubles didn't help his credibility?
Not at all. He returned to Australia, was later convicted of rape, and then was stabbed in prison, which his wife claimed was a direct result of his testimony in Bali.
So the defense was essentially stuck. They had the word of the customs officers on one side and the highly dubious claims of a convicted criminal on the other.
It's a terrible position to be in, and it's a perfect example of a defense that's struggling because it has no objective physical evidence.
Which brings us to what many people consider the single biggest procedural failure of the entire case.
The denial of forensic testing.
This detail is just so pivotal. The sources are very clear. The cannabis was never fingerprinted by Indonesian officials, nor was it analyzed to determine its point of origin.
And both of those things matter so much. Fingerprinting was essential. If Schapelle's prints were absent from the package, it would have strongly supported her claim that she never handled it.
And the origin testing.
Equally crucial. If the analysis showed the drugs were grown in Australia, it supports the baggage handler theory. If it showed they were grown locally in Indonesia, well, that points to a completely different scenario, possibly clearing her of being the original source.
And both of these requests were just flatly denied by Indonesian authorities.
They were, and this is where the diplomatic friction really starts to show, because the claims about who advised against the testing are in direct conflict.
What are the two versions?
Well, one version that was reported was that the Australian Federal Police, the AFP, advised against origin testing.
Why would they do that?
The fear was that if the results proved the drugs were Australian, they would be forced to share that information with Indonesian prosecutors, which could have actually bolstered the Indonesian case against her without providing any real benefit to her defense.
And the other claim is that the refusal came directly from Bali.
Exactly. The counterclaim is that the Bali police simply refused the Australian government's request outright, citing their sovereign right to control their own investigation and how they handle evidence.
So we don't know for sure who made the final call.
The truth is obscured, but the result is the same. The defense was denied the only objective scientific evidence that might have supported her claim that she had no intent.
And the prosecution's response to the lack of fingerprinting was just so simple.
It was. It was unnecessary because she was found in possession.
That one statement really encapsulates the whole conflict between the two legal systems, doesn't it?
It absolutely does. The Indonesian approach prioritized establishing simple liability. She was in control of the drugs. The Australian defense was trying to introduce the complexity of mens rea, of criminal intent, but because that intent couldn't be proven or disproven forensically, the fact of possession became the default, insurmountable proof of guilt.
So despite all the procedural questions and the defense's valiant, if flawed, attempts, the day of the verdict arrived. But first, Schapelle made one final plea to the judges.
She did, on April 29th, 2005. And you have to remember the intense pressure she was under. She was a young woman, totally isolated, facing the prospect of decades in one of the world's toughest prison systems.
She spoke directly to them.
She told the court, "I cannot admit to a crime I did not commit. And to the judges, my life at the moment is in your hands, but I would prefer if my life was in your hearts. I beg for justice. I don't know how much longer I can do this. Please bring me home."
That plea really speaks to the immense human cost this trial was already taking.
It does. Then on May 27th, 2005, the verdict came down. It was broadcast live in Australia, which tells you everything about the depth of the national obsession with this case.
She was found guilty and sentenced to 20 years.
20 years in prison, plus a very significant fine of 100 million Indonesian rupiah. That was about 12,600 Australian dollars at the time, and there was an additional 6 months added if that fine went unpaid.
And that verdict was just the start of this long, torturous appeals process that went back and forth.
A very fluctuating process. Can you outline those changes for us?
Yeah. Initially, her sentence was actually reduced. Bali's High Court cut it to 15 years in October 2005.
So a small glimmer of hope for her.
A momentary one. But in January 2006, The Indonesian Supreme Court overturned that reduction. They reinstated the original maximum 20-year sentence.
And crucially, the Supreme Court also ordered that the bodyboard bag and the drugs be destroyed.
Why is that significant?
It signaled the absolute finality of the criminal investigation and the judgment. The evidence was gone.
So once the Supreme Court put the 20 years back on the table, her only remaining option was clemency.
Right, which is a political action, not a legal one.
And she pursued it on explicit humanitarian grounds, citing her severely deteriorating mental health.
The appeal went directly to the president, Susilo Bambang Yudhoyono. And in a pretty significant move, in May 2012, he granted her a 5-year sentence reduction.
This just highlights the immense diplomatic tension surrounding the whole case. What was the Australian government's official stance during all this, especially under Prime Minister John Howard? The public pressure to intervene must have been intense.
It was enormous. But the Australian government was caught between this overwhelming public sympathy for an Australian citizen and the ironclad diplomatic principle of non-interference.
So PM Howard expressed sympathy, but held the line.
He did. He consistently said that Australia would not and could not dictate how Indonesia's judicial system works.
And why was that principle so strictly applied?
Because the diplomatic relationship between Australia and Indonesia is incredibly sensitive, but also vital. As Howard pointed out, Australia would react very angrily if a foreign government tried to tell us how to handle a case involving one of their nationals on our soil.
So violating that principle would have had much bigger consequences.
It could have fundamentally damaged the entire bilateral relationship, and it could have jeopardized the hundreds of other Australians facing legal issues in Indonesia. It was a trade-off. Adhering to diplomatic protocol meant sacrificing the ability to pressure Indonesia on things like forensic testing.
And on the other side, how did the Indonesian public and politicians react to that 5-year clemency she was granted?
They reacted very strongly, which shows you the huge difference in how the two cultures viewed drug offenses.
They thought it was too lenient.
Far too lenient. Anti-drug activists and politicians in Indonesia widely criticized it. The sources record one politician arguing that Corbyn deserves the death penalty. Editors claimed her release was highly offensive to their national sense of justice, given Indonesia's extremely strict anti-narcotics stance.
That disparity is just immense. It shows the cultural gap they were trying to navigate. Now, before we get to her time in prison, we have to mention a really controversial claim that surfaced while she was inside.
Yes, the allegations from 2014 made by a fellow convicted drug smuggler.
Brene Lawrence, one of the Bali Nine.
That's right. Lawrence alleged that Schapelle had confessed to her. She claimed Schapelle admitted to having prior knowledge of the drugs and that she had even successfully completed the same international run twice before without getting caught.
That accusation, coming right as Schapelle was applying for parole, threw a massive wrench into the narrative of her innocence that had been so dominant in Australia.
It remains one of the starkest, most uncomfortable conflicts in the entire case file.
So Schapelle ended up serving 9 years in Karabokan prison.
She did. And the conditions, as they're described in the sources, were extremely harsh. She was in a shared cell block with about 85 other women.
But she tried to keep busy.
She did. She tried to occupy her time with creative things like making jewelry, just in an attempt to maintain some kind of routine and, well, sanity.
But the most profound and distressing part of her time in prison, and the thing that really garnered the most humanitarian sympathy, was the mental health crisis she went through.
The sentence took an enormous personal toll. Her struggle with severe clinical depression and multiple debilitating bouts of psychosis is very well documented.
She had to be hospitalized several times.
Yes, particularly in 2008 and 2009. The stress of the trial, the conviction, the isolation, it just seemed to completely overwhelm her stability.
And she later spoke about just how deep her despair was.
She described being out of her mind literally for about 4 years, especially after her father died in 2008.
She became catatonic at times, is that right?
That's how she was often described, unable to speak or move. It's a truly heartbreaking state for anyone to be in. An Australian psychiatrist assessed her in 2009 and explicitly reported that her mental condition was deteriorating very seriously and urged that she be transferred to a proper hospital facility.
The sources also highlight the almost perverse role the media played in making this health crisis even worse.
Yes, the media scrutiny was just relentless. In 2008, she was permitted to leave her hospital ward under armed guard to visit a hospital beauty salon.
A decision that was controversial in itself.
It was. And when she left, she was immediately swarmed by this massive, aggressive scrum of reporters. Her doctor later said that her condition regressed back to zero. and that she needed immediate further treatment for depression right after that intense public exposure.
It's a cruel irony, isn't it?
Yeah.
The very same media that generated so much support for her was also actively damaging her health.
It is, but we do have to acknowledge the counter-narrative. Not everyone believed the severity of her illness was genuine.
This comes back to Renee Lawrence.
Primarily, yes. Lawrence championed the claim that Schapelle's mental illness symptoms were faked, or at least exaggerated.
And why would she do that?
According to this account, the performance was intended solely to attract leniency, to secure those sentence reductions, and to increase the chance she'd be granted parole on humanitarian grounds. We have to report that claim as part of the narrative without drawing any conclusions.
Right. But despite those conflicting claims, her humanitarian appeal for clemency, based on her health, was successful. It led to that 5-year reduction.
And that reduction made her eligible for parole, which she eventually got.
She was released on February 10th, 2014, after serving exactly 9 years.
And a crucial detail that allowed her to accept the parole was that the conditions did not require her to admit she was guilty.
So she could maintain her innocence while still getting out of prison.
Exactly. It allowed her to stick to the planted drugs defense while securing her release.
But it wasn't total freedom. There were very strict conditions.
Extremely strict. She had to stay in Bali, live with her sister Mercedes, report to the Corrections Bureau every month, and she could not leave Indonesia without explicit official permission.
And that lasted for another 3 years.
Until her final release date on May 27, 2017. Her return to Australia was conducted under this overwhelming, almost military-style security detail.
To protect her from the media frenzy.
The media frenzy that was accurately described by everyone as an absolute media circus.
So even after her return to Australia, the public scrutiny, the controversies around Schapelle and her family, they didn't just go away.
Not at all. The legacy of the trial and the continued speculation about her guilt ensured she remained headline news.
We can trace some of this back even earlier to just after the conviction with the whole Malcolm McCauley issue.
Right. Australian police seized some photographs that showed Schapelle with McCauley, who was a convicted drug trafficker in South Australia.
And the initial media reports suggested these photos were taken before her arrest.
Which would have implied a pre-existing link to the drug world. But McCauley clarified the situation. He said he'd visited her in Karabokan prison twice in 2005 to offer support during her trial.
So the photos were taken inside the prison.
Yes, at an empty fish pond with permission from the guards.
But even though they were taken during her imprisonment, the timing of their public release was disastrous for her legal battle.
It was. Bali prosecutors publicly said they were concerned that the judges who were considering her appeal would potentially increase her sentence in light of photographs showing her with an alleged drug smuggler.
So it created a perception of guilt by association.
It did, and the following month, the Indonesian Supreme Court reinstated her full 20-year sentence. It just shows how perception, even if it's refuted, can have very real consequences in a case this high profile.
And compounding all of this were the documented claims about her immediate family's own connections to drugs.
Which the media eagerly pulled together, fueling this public belief that the Corby family was, generally involved in the drug trade.
So let's go through the specific details from the sources.
Well, her father, Michael Corbin, who passed away in 2008, had been fined back in the 1970s for possessing 2 grams of cannabis.
A minor offense from a long time ago.
Yes, but more recently, he was linked to a property near which 5 kilograms of cannabis were seized just 1 month before Schapelle's arrest.
Did they ever link him to it directly?
Queensland police later stated they had no definitive evidence linking him to the drug trade, but you can see how the optics were undeniably poor.
And the speculation only got worse when her half-brother, James Cassina, who was traveling with her on the day she was arrested, was himself convicted of a drug-related home invasion.
Yes, assault and possession shortly after her sentence was finalized. Cassina was sentenced to 4 years, though it was suspended after he served 10 months on remand.
But for the public, the important thing was the timing, the clustering of all these events.
It was. For many people, these family incidents provided circumstantial support for the prosecution's belief that Schapelle must have had some knowledge of, or at least a casual relationship with, the illicit drug trade, despite her consistent denials.
And then came the most dramatic allegations of all, from a former family friend.
Jody Power.
She appeared on a current affairs show, in a paid interview, and made some very specific and damaging claims.
She did. Power alleged that Schapelle's sister, Mercedes, had previously asked her to transport drugs internationally.
And she even claimed to have seen a vacuum-sealed plastic bag, similar to the one found with the cannabis, at Mercedes' house.
And if that wasn't enough, Power also alleged that she had seen Schapelle herself use various illicit substances, ecstasy, speed, and cocaine.
How did the family respond?
Mercedes Corby vehemently denied all of it. She called them disgusting lies designed to sabotage Schapelle's appeal. Mercedes did admit, under questioning, to having the occasional puff of marijuana as a teenager.
And this led to a big legal battle.
A significant one. Mercedes sued the broadcaster for defamation.
What was the outcome of that case?
It was eventually settled out of court. But during the proceedings, a jury did uphold the broadcaster's defense of truth in relation to the claim that Mercedes possessed marijuana, which confirmed at least one small facet of the broader claims. The whole episode just solidified the media narrative that the family operated in proximity to drugs.
We also need to talk about the complex issue of profiting from her story, the profit of crime debate in Australia.
Yes. After her conviction, Schapelle released her autobiography, My Story, in 2006. It sold over 100,000 copies.
And that immediately ran into Australian laws designed to stop convicted criminals from capitalizing on their notoriety.
The proceeds of crime laws. They allow the government to freeze and ultimately seize any income that's derived directly from a criminal offense or the story of that offense.
So what was the legal tactic they used to try and get around these laws?
Well, in what was widely seen as a calculated legal maneuver, the book's copyrights were immediately assigned to her sister, Mercedes, and to the co-author.
To try and legally distance Schapelle from the money?
Exactly. The argument was that if Schapelle didn't technically own the copyright, then the profits weren't technically hers.
And did that work?
No. The Australian government moved very quickly to freeze the profits. In March 2007, the Queensland Court of Appeal barred the family from spending any of the book's income while the Commonwealth proceeded with its claims.
And how much money was frozen?
Ultimately, an amount of $267,500 generated by the book was frozen, pending final forfeiture. It just underscores the immense legal complexities and the state's determination to prevent convicted criminals from benefiting financially.
It's clear that even after 9 years in prison and her deportation, Schapelle has become this permanent public figure, a kind of celebrity born from controversy.
Precisely. She's maintained a very high degree of visibility. She's appeared on major Australian reality TV shows like SAS Australia and Dancing with the Stars.
And she even released a pop song.
She did, Palm Trees, in 2018. She has cemented her place as this enduring media persona, despite, or, maybe because of, the ongoing questions about her guilt.
That continued public engagement just ensures the controversy never really dies. The sources even mention her advocacy for the missing child William Tyrrell, which was sadly met with dismay by the child's family.
They didn't want the association with her public profile. It shows that even when she attempts to engage positively, her efforts are still weighed down by the historical context of her conviction.
So to bring this very intricate analysis to a close, let's just summarize the key tensions that really define this case.
Well, we have the core conflict. Her conviction rests entirely on the testimony of customs officers, and the simple fact she was found in possession of those 4.2 kilograms of cannabis.
And on the other side, you have her consistent, unwavering claim that the drugs were planted.
A claim that gained a lot of traction because of the multiple failures of the initial investigation to secure key objective evidence.
Like the crucial CCTV footage.
And the procedural denial of proper forensic testing, the fingerprint and origin analysis that was never done.
Her long, torturous path through the Indonesian legal system saw an initial 20-year sentence, which was briefly reduced to 15, then aggressively put back to 20.
Before finally being cut by 5 years because of that successful humanitarian clemency appeal, which was based on her severe mental health crisis.
And that appeal, however necessary it was for her well-being, really exposed the stark legal and cultural differences between Australia and Indonesia.
It did. It placed the Australian government on this diplomatic tightrope where non-interference was prioritized over intervention, which ultimately limited what the defense could do.
The entire saga really morphed from a criminal case into a national cultural moment. While public opinion was, and still is, fiercely divided on whether she's guilty, many felt the trial itself was fundamentally unfair.
Especially given those procedural denials. And the case had a direct, measurable impact back here in Australia. It led to an immediate increase in the sales of luggage locks.
And people started filming their luggage at check-in.
Yes, as a direct precaution against suffering a similar fate. It transcended a cautionary tale and became a national conversation about trust, sovereignty, and the limits of state protection for citizens when they're abroad.
And that brings us to a final question for you, the listener, to reflect on. Despite Schapelle serving 9 years, despite the mountains of media coverage, essential facts like definitive forensic evidence proving or disproving the drug's origin or objective proof of whether the drugs were planted, they remain entirely obscured.
So how does this fundamental lack of definitive physical evidence, those missing fingerprints, that denied origin test, how does that allow speculation to sustain itself for decades? How does it transform a legal conviction into an enduring national myth that continues to capture our attention and define a major chapter in Australian legal and media history?
That's certainly something to ponder.
Indeed.
Thanks for listening.